Well, hello. Hope you all are doing well today. We are rapidly heading towards summer. Uh, lots going on. Lots going on here at ASMP and at Nampa. A number of trips, number of things occurring, um, and we're going to talk about some of them today because they relate to advocacy. So we're just going to give it one more minute, and then we will get started. Now, as a reminder, at the bottom of your screen, you should see a Q&A that will, let's see here, that will allow, oh, it looks like chat was toggled off. So now you can try. Now you can try, and I bet that will work. Um, there's a Q&A tab at the bottom of the screen. If you have a question about things we talked about today, a big part of this town hall is meant to have you be able to ask questions and we can talk about things. So definitely put your questions in that Q&A box. That's going to be the very best way. And it's going to be the very best way for us to keep track of everything. So, and thank you for those of you who already use the Q&A box. Let me know that chat was disabled. You did exactly right. And now it is working. So, all right, perfect. Well, cool. Okay, everything should be going, and so we're going to go ahead and get started. A couple of minutes past the hour here. Want to welcome you today to the second session of the new town hall series, Creative Focus. We were really excited after the first one because it's obvious that there's a place and a need to have these discussions. And, as I mentioned previously, we feel very strongly at ASMP about making sure that when we do lend our voice to an issue, it has come from a reasoned perspective, something that we feel we absolutely understand, and at least in the moment, how it affects our members and the community at large. And so today we're going to continue our discussion on AI. Obviously, we're going to be looking at some specific clauses that we've written that are going to be distributed. And I know there's a lot of members who are not here. You guys will get to see them too. Now, you won't see the full contracts. Those are in our document library for the membership, but the specific AI clauses, we want everyone to be able to take a look at and everyone to utilize because they're incredibly important. But more important than a specific clause is the understanding that goes behind that clause. And this is what we always say about contracts, right? A contract, its only purpose in the world is meant to facilitate an understanding between two parties. And the best contracts are not ones that are forms or templates or that type of thing. The best contracts are ones that actually answer the questions that you're trying to answer in whatever situation you're in. Contracts that when we talk to members, you know, an agreement, something that's legal, can be as short as a text message or as long as 100-page document, and they're both legally sound as long as they answer the questions that the document's trying to answer. So I don't want you to get caught up on specific formalities, but we're going to go into the thought process behind what we're talking about today. So, all right, let's go ahead and jump right on in. Now, I'm going to share my screen. If you've been to any of the town halls that we've done before, whether this year, last year, 5 years ago, 8 years ago, you know that I like to jump back and forth because we got a lot to talk about today. But let's go ahead and get started. All right, so hopefully everyone can see that. First, definitely want to say thank you to PetaPixel. PetaPixel has been a supporter of this new town hall series. We were happy to have the editor-in-chief, Jaron Schneider, join us last week or last session. And we have some really great special guests coming up in the weeks to come, which I can't wait to tell you about because they are right on point with the conversations that we're having here. So definitely thank you to PetaPixel and thank you to all of you for coming today. Our next town hall is already scheduled. It will be 2 weeks from today at 3 p.m. Eastern. This one was a little odd. It was 4 p.m. Normally they're going to be at 3 p.m. And so we definitely want you to attend. The registration links and other things for that will be up very shortly. You'll see those in all the normal places. And there will be a post session wrap up email. It's going to have a bunch of links for you because we have a lot of documents and other things today that we want to make sure you have access to. We're going to put some links in the chat, but just in case you have to take off or for your reference in the future, we're going to include those in the email that gets sent out to you all as well, which will include a registration link for the next session, which will be on May 20th at 3 p.m. If you want to see the recording of the first session, if you missed it for any reason, you can visit us at our YouTube channel. And I put the link down there. Go ahead and I'm going to copy this and stick it in the chat so that everyone can have it. And you know what? We are really just at the very beginning stages of getting our, let's see here. Make sure that's it. Yep. Getting our YouTube channel going with some of the amazing hundreds and thousands of hours of content that we actually have over at asmp.org. But please subscribe. And when you go there, you will, I'll show you a few things that might be of some kind of interest. So if we share that screen there and you go to our YouTube channel, well, the first one from last week is up here. If you want to have if you want to watch a really interesting conversation, there's the conversation we had during the 80th anniversary with Santiago Leon of the Content Authenticity Initiative. This also over here inside the room, how creative directors really choose who gets the job. That's a really cool panel that we did. We have one on copyright. We have playlists. We have lots of stuff, old town halls. So please subscribe. We'd love to have you there. Okay, back to it. So if you missed the first one, please go and watch that. Okay, so what's the goal today? Well, the first thing we're going to do is give an advocacy recap talking about the Copyright Office, the proposed fee increase, the ALI restatement petition, which got a lot of emails about this morning because you all got a lot of emails about this morning. It was already on the agenda for us to discuss. And so really wonderful timing on that because we have some info on that for you. And then but then we want to use this session to build on the previous session and discuss AI. But this time we're going to look at specific clauses and revised documents and how you can incorporate these types of things into your contracts and your agreements starting today. No reason why not to. We want to go through that mental framework, right? We want to go through the thought process, a decision tree when it comes to thinking about AI, thinking about how the best way to incorporate these protections and these concerns, and what should you be concerned about, and what should you be worrying about, and so that's our goal for today. Real quickly, wanted to mention if you're anywhere in the Pacific Northwest, I think there's literally like 5, 6, 7 tickets left for PDX Squared. That's happening next Friday and Saturday in Portland, Oregon. It's one of the coolest events that ASMP puts on. And I'll be up there. Our COO, Melanie Porter, will be up there. And so if you want to come and hang out with us for a couple days and take part in a really exceptional event, I definitely encourage you to come and check that out. We got some incredible companies that are involved, including our title sponsors, Adobe and Fujifilm, that are like sending the whole crew up. We're really excited. It's going to be a lot of fun. And yeah, I see Verena there in the chat. She'll be up in Portland with the Fujifilm team, and we'd love to see everyone up there. It's going to be a whole lot of fun. Okay. So let's talk about some recent advocacy issues. And there's 3 things that we want to discuss today. And I'm going to be jumping around on screens a lot because I got a lot of stuff that we want to look at. We want to talk about the aftermath of the Copyright Office fee study that came out and comments that were due recently. And we're going to touch on a few details there. We want to give you some background and an update on this ALI restatement of copyright project and the reason that people are all up in arms and the reason that we're going to ask you to sign a petition today. I think it's an important thing to do. And we're going to talk about an upcoming hearing that's going to be taking place next week in Washington, and why it matters and how you can watch it if you have interest in that direction. And so those are the advocacy things we're going to touch on before we jump into AI. Okay, here we go. So on March 20th, the U.S. Copyright Office issued an NPRM, which is a notice of proposed rulemaking outlining the new fee schedule for people to register. And when an NPRM is issued, there's a period of time where comments can be submitted. And so, as part of what we do each and every week, we are involved with different organizations. Sometimes we write comments independently. Sometimes we write comments with other groups. Sometimes other groups sign on to our comments. We see a lot with amicus briefing that you all have heard me talk about before. Because we want to make sure that our voices are heard. And on this particular occasion, we have worked a lot with our partners over at the Copyright Alliance. Copyright Alliance, if you're not a member of the Copyright Alliance, we encourage you to go be, because being an individual creator member is free. You definitely should. It's an amazing group, which is probably the largest voice of copyright owners who are fighting for the same things often that we all are fighting for. But it not only includes groups like ASMP and individual creators, it includes the largest companies in the world who are working on behalf of finding the right balance with copyright. Now, we don't always agree on issues, and there will be maybe we'll do a town hall in a few months of just kind of war stories on advocacy issues, because some of them are pretty entertaining, but we agree on a lot. And the Copyright Alliance is a really great organization, so they filed comments that we included some things that we proposed, and we're going to look at some of that here in a second. So on May 4th. The Copyright Alliance did submit those comments, which included some of the positions that we'll look at. But first, before we look at that, if you are interested, and here I will switch for a quick second. If you are interested in this fee study, you can go to this link right here. Let me pull it up. And you can read this fee study. I will also tell you that you do not want to go read this fee study, because it is very long and it is not particularly interesting. And this is the actual study itself, and this comes in what they call the Federal Register. And so every day this comes out, and this was on Friday, March 20th. And over here, the fee study NPRM, Notice of Proposed Rulemaking, begins. And it talks about all the various issues that we're about to discuss. It's a little maddening, to be honest, because many of the things that we're asking for are things that we've been asking for years and years and years. And we're going to talk about what our approach to that is, probably in future town halls. But going back and looking at this, the one thing I wanted to point out is here under this fee study, a group registration of unpublished photographs and published photographs up to 750. They propose it's currently $55, and they propose that it goes to $85. That's a 54% increase in price. Now, they say that it costs them $150 to actually do it, so $85 is a bargain. Respectfully, I do not agree with that for a number of different reasons. But this is one of the important parts of the fee study. And so, as I mentioned, we look at these comments, and we file comments with other groups. And so here are the comments that were sent from the Copyright Alliance, which represents over 2 million individual creators and 15,000 organizations in the United States. They are very large. You all have heard us talk about VACRA and how VACRA, the Visual Artist Copyright Reform Act of 2025, which was introduced in December, is important. And so one thing we said when we were working with the Copyright Alliance to create these comments is we said, hey, be sure to include VACRA in here because it has some good solutions. And so there's a section in these comments that say, we believe that IT modernization had the potential to relieve cost burdens and, here are the ways it can do it. And then this whole footnote is about VACRA. And VACRA is something that you're going to be hearing a lot more about this particular year. And then, again, group registration applicants are especially affected by the proposed fee hikes. And this is something that, that is where our focus is, right? And so we're talking here about the 750 limit on works in a group registration for photographs. And, the comments here include, it's misleading to discuss that fee on a cost per photograph basis, which is what the Copyright Office does, because the likelihood that more than a few of those 750 will ever benefit from registration is exceptionally low, right? So, these comments, the original NPRM, all of these things you can find links to. We'll put some of them in the chat for you as well. But this, we wanted to follow up on. These comments have now been submitted. We are going to hear about that probably pretty shortly, as you will see in a moment. Okay. So we just took a look at all this. Okay, so stopping for a quick second, and we're gonna jump back to the second advocacy piece. But if you're new to some of these town halls, if you're new to ASMP, maybe you're not a member, maybe you just saw a link and decided to pop in today. This is a good time to pitch the fact that all that we do and all that creators in the US do, and worldwide, frankly, is the core of it is your copyright protections, right? And copyright law and the different elements of copyright law and the different changes that are made to copyright law matter. They matter to each of us, whether we realize it or we don't. A big part of what our job is here at ASMP is to fight for these rights and to make sure that the changes in copyright law are ones that are not beneficial to a particular group of creators, but beneficial to society as a whole. Society is made stronger when you all are out there doing what you do best, which is taking pictures, right? And so when we go to Washington and talk to lawmakers about why these things are important, they're important because these directly affect the ability of photographers and videographers like yourselves to be able to contribute to the visual world in which we live, right? It is something that we feel incredibly passionately about. And when I go to Washington, I get to talk about these issues and I say, look, some economist somewhere said that it costs the Copyright Office X dollars to review a copyright application, but let me explain to you what that copyright application actually means to that photographer and how protecting their work actually affects their lives, right? That's why we're here. That's why we do what we do. And so when we see things in the law that are concerning, it raises a red flag. And one of the most concerning things that we've seen lately is this thing called the ALI Restatement of Copyright. And so this morning, Workbook sent out an email to its members that mentioned this in particular. And so what a wonderful coincidental time to talk about this. I'm going to dive into just a little bit of legal nerd talk for a minute, and hopefully you find it interesting. And again, feel free to use the Q&A if I know I'm going through a lot of stuff. So if you have questions or topics you want me to talk about, let me know, because I can't always check the chat. So please do put in the Q&A. That's the best way for me to actually see what questions you have. So in the law, there's been an extrajudicial source of information, and they're called the restatements. And so you have like restatements of contracts, restatement of torts, restatement of these different areas of law, right? They're created by this group, the American Law Institute, ALI, and they're really influential. Right? Uh, these compendiums are something that every law student learns about, every lawyer uses. They are critical pieces. I think on day one of law school, you talk about restatement of contracts and why it's important and what it means. But previously, the restatements were almost always cabined to cover parts of law that where there were differences between states and where state law was primary, right? And so, that what I mean by that is if you have a contract dispute, you're going to adjudicate that dispute in a state court. Okay. But if you have a copyright concern, copyright is entirely federal law. That's all it is. There's no special state copyright law. There's federal copyright law. It is a part of the law that is what's known as preempted, right? So federal law preempts any kind of state law on these issues. And that's different for contracts, and it's different for torts, it's different for all these other areas of law. And that's why the restatements were important, because they made it so that there was kind of one central area that courts could look at and say, hey, here are the kind of general best practices for these different areas of the law, right? Now, so in 2015, ALI decided, well, we're going to make a restatement of copyright law. And that was a concern. And it was a concern to a lot of people, but we gave them the benefit of the doubt, right? So for the first time, ALI was going to restate an area of law that was purely federal, and where there were no disagreements in general between states on these issues. So fast forward 10 years to 2025, and there's a draft that was produced in May of last year, so about a year ago now. And it was ridiculous. It wasn't something that was reasonable in a lot of dimensions. And we're not going to have time to go into exactly why, but we'll talk about a few of them. And the leading voices in copyright law, including law professors like Jane Ginsburg, Keith Cooperschmidt, who I just mentioned is the CEO of the Copyright Alliance, attorney Nancy Wolf, many, 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 many others who were invited to be on this advisory panel back in 2015, resigned in protest when this draft came out. That was kind of unheard of, where, I mean, a huge swath of the people that they had invited in to help define what this treatise should look like left, and they said, hey, this is not right. This is not okay. And like I said, we're not going to go into all the details now about it, but I'll bring up one kind of connection here with ASMP, and that is, we worked very hard in the Andy Warhol Foundation versus Lynn Goldsmith case, right? We worked very hard on behalf of Lynn Goldsmith, an ASMP member, in the U.S. Supreme Court, writing amicus briefs and other supporting documents, because there were arguments that were saying the use that the Warhol Foundation had made was, quote, fair use, right? Fair use is an element of law. In the Restatement of Copyrights draft that came out, there were an interpretation of fair use that did not comport with anything that we would consider reasonable. And so essentially, what you have here is a situation where this book might go out into the world that every judge and every lawyer believes is authoritative. And it has information in it that not only, it's not like two reasonable people disagree on something and so maybe it makes sense. It's that it says this is the way it should be. And that way that it said in that draft is entirely. And so, that spurred a number of different things to happen, including things like the Copyright Restatement Transparency Project. And that was a link that many of you all have sent over, and one that we want you to check out. I will go ahead and put the link here in the chat in a moment. And the petition and all the details, you can find it. You can find it right there. Let me throw this link in here. There you go. And so let's take a quick look over at that. Okay. So yeah, here at the Copyright Restatement Transparency Project, it talks about, it goes into the history of the ALI and all of the various people who resigned from this. These are household names when it comes to this little corner of the world in copyright law. It talks about why there were people resigned. Keith's statement is here and is quite good. I encourage you to read it. But what can you do? Well, once you read through this, and again, this may not be the most riveting stuff in the world, but the end result is important. You can sign this petition and then join the group of people who say, "Hey, this isn't right, and we want to make some changes here." Now, look, the truth is that if all of these names resigning haven't moved the needle yet, I'm not sure what will, which is why I think a petition is a great idea. And I encourage everyone to sign. And I signed it on behalf of ASMP, and we're a vocal supporter of not only this project, but others that have pushed back against the ALI and their restatement of copyrights. And if and when it does make its way out into the world, we will be very vocal with courts and judges and lawyers about the fact that they should not be relying on that it is not a reliable source for reasons X, Y, and Z. So I wanted to bring that up because I know that's something that a number of you had reached out to us on as well. Definitely encourage everyone to sign the petition. Thank you, John, for signing it. I hope everyone does. It was at 633 this morning, and it's already in the 680s, 90s. We're very happy to have everyone involved there. Okay. Let's keep going. Now, upcoming things to keep your eyes on. Okay. Upcoming things to keep your eyes on. Next Tuesday at 2:30 p.m., that's May 12th, there is going to be a hearing in the Senate IP subcommittee with the sole witness being the Register of Copyright Chair Perlmutter. Now, if you watch this hearing, you'll notice that senators will ask questions of the witness, and the questions are really important because the questions put the Copyright Office on the record about different issues that are coming up. We'll be very interested to hear what Register Perlmutter has to say. And if you want to watch it, you absolutely can by going to this link right there at 2:30 Eastern on next Tuesday, right? Now, I will be up there. I'll be going up to Washington next week. This hearing is an important hearing. It is important for a number of reasons, but one of the reasons it's very important is because of VACRA, the bill that was introduced in December that ASMP wrote in a lot of dimensions, and something we're very passionate about here as we go into this year on the advocacy side. Because what VACRA is, in many cases, is a bill not about copyright law, but about the Copyright Office, asking the Copyright Office to do certain things. But we've been asking the Copyright Office to do those things for quite a while. And, I think that we've had a good relationship with many of the people at the Copyright Office. But despite that relationship and some of the positive things that have come out of it, including the CASE Act and the implementation of the CCB, we haven't been able to reach this next hurdle. And it's one that we work on every single week. And so we definitely want you to keep an eye on these things when they happen, because your voices matter. Again, when I go up to Washington, I don't talk about the reasons I like copyright. I talk about the reasons copyright matters to you guys in your lives, into your careers, because that's what matters. And that's what the many lawmakers understand, you know? And so we try to make it personal, and we try to make it clear. And then we try to get changes made. One of the best ways to get changes made is these type of subcommittee hearings where senators will ask direct questions of the Copyright Office. And when someone answers those questions under oath in a Senate subcommittee hearing, that is something we can rely on. Now, if you are used to the world of Washington in any capacity, you know that out of hours of back and forth, there might be a few minutes of, really important stuff, right? Because there's a lot of talking in circles around things and people not wanting to commit to other things. That's what VACRA does, is it helps, find those commitments. Instead of us asking the Copyright Office to do something, it's Congress telling the Copyright Office to do something. We're not the bosses of the Copyright Office, but senators and Congress people are. And so we hope that between all the various issues we've been talking about today, and the introduction of VACRA and these types of hearings and the responses to the fee study and all these issues, that we can affect some real positive change this year. We are going to get behind VACRA in a way that the organization hasn't since the days of the Case Act, which many of you all remember. And so, this is something that we're going to activate you on later on this year. And we definitely appreciate your support because it matters. We'll be talking with you about your stories. We will be taking those stories with us when we go to Washington, and it makes a difference when we talk with lawmakers. So, okay, now let's switch gears into generative AI and the legal considerations that we want to talk about today. And again, I want you to think about a framework for generative AI. I don't want you to think about a formula, right? This is not an 1 + 2 = 3 situation. What this is identifying the issues, determining if those issues apply to you, and if they do apply, then knowing how to react and respond to them. So, and there are there are literally hundreds of issues we could talk about, but we're only going to talk about 3. Well, we're going to talk about 2 main areas, and then we're going to add 1 at the end. So, um, the first area is input, right? When we talk about generative AI and we talk about the use of images for training purposes, we're talking about the input of images and using images as source material for generative AI models that are at the center of everything that we're talking about right now. And then we talk about output, and that's the product. That's also where we talk about things like manipulation, and we talk about things like post delivery editing, and cover those type of areas. And both of those areas can be covered in your agreements and your contracts, right? Now, we're going to touch on those 2 first, and then at the very end, we're going to switch gears to how you protect yourself in a different way. And this is something we alluded to at the last town hall. But you have to consider what matters to you, okay? And I will stop sharing for a second because I think this is an important element. Just looking at the people who are in this webinar, whose names I recognize, and there's a lot that I don't recognize. You all are all over the map with the type of work that you do. Some of you are filmmakers. Some of you are photographers who work on the commercial side. Some work in real estate. Some work in portraiture. Everything is different. The types of clients you work with are different. The industries you serve are different. And different industries right now are adopting generative AI technologies in different kinds of ways. There's some areas, and I mentioned this last time, there's some areas of photography that are not only, let's say, anti-AI, but rightly so, right? Photojournalism is an area in which we want to, as a society, have confidence in the truth of the images that we're seeing. And so Our friends and colleagues over at NPPA have some distinct rules about AI that might be a little bit different than rules you would find elsewhere. And for those of you who are in purely creative advertising type worlds, AI may have more of an impact on your workflow, and it becomes part of what you do. So what we are not doing is sitting here and saying AI is bad, AI is good, AI is this or that. Generative AI is a tool that you can use at various points in your workflow. It's also a tool that your clients can use. And that's the first piece that we're going to be talking about today. How do you prevent what happens with your images once you deliver them to a client? And the way that we've done this throughout all of professional photography forever is this idea of a license agreement, right? And so a license agreement, which is ubiquitous in the world, we enter into license agreements all the time. But in photography, a license agreement says, hey, uh, you can use this image. I will retain the copyright. Again, one of the reasons copyright's important. I, photographer, will retain the copyright. And you can pay me X dollars, and in return for that, you can use the image in these ways. And then you get to pick and choose from literally the whole world of options. You can say, you can only use it in North America. You can only use it on a first printing. You can only use it for a year. You can only use it online. You can only use it in a book run of up to 10,000, whatever you want to say, right? Elements of a license agreement are entirely up to you. But it's time we start thinking about some new elements. And those elements are AI related. Because we are at the tail end of the largest theft of intellectual property that has ever happened in the history of the world. If your images were online in the last 5 years, they have been scraped and they have been used to, quote, train generative AI models. I put train in quotes because that was actually one of the things that we thought about very early on. You know, the technology lobby and strategists for companies that were creating these models are very good. And one of the first things they did was they made generative AI models feel very human. So you trained them on things, right? You didn't steal pictures, you were training, they were using words that helped familiarize the public with these models. And now they're words that everyone uses. It's kind of like, okay, well, the ship sailed on that. And so, we use the word training because it's something that everyone knows. But it wasn't training really, at least not in the last few years. It was just that, right? That's concretely our position. Now, there are roles for training in the future. And many companies are developing, big and small, are developing local generative AI models that are based on their photo libraries or based on their set of images that they use for training. And that's where the first clauses come in, right? Because you get to control whether or not your work is available to be used for AI training. Just like you get to control if your work can be put on a billboard or it can only be used on a website, or if your work can be printed here or there, whatever the case is. This is an element you can control. So it becomes an element of your license agreement. Okay. It becomes an element of your license agreement. Now, it is an element that, because it's so new, we may want to highlight. And we're going to talk about different ways to do that. But someone should pay you for the right to use your images to train a generative AI model. Okay. And that is something, just like the AI lobby was able to convince everyone that this is training, our job, meaning ASMP and groups that we work with, our job is to convince everyone that if you want to use a photo for training, you got to pay for it, just like you do with everything else in the world. You can't just steal someone's car and then say, I was learning how to drive, right? That doesn't work. This is a commodity. This is an element that you, photographer, can put into your license agreements that says, sure, no AI training, but it's licensable. So if you want to pay me and you can use it in your local model, generative AI model that you're creating in your business, fine. Because a big difference now from decades ago is that we are in a world where, and I'll speak personally, my view is that you need to stay in business. And we are not in a world of absolutes, especially right now with generative AI. The ability to license your work in every dimension is a right that you own as the copyright holder. You get to decide how it's used. And if that means it is not to be used for AI training in the future, absolutely say that. And by the way, that should be the default. Okay. That should be the default. But what if a company comes to you and says, hey, we want to have the ability to do this? Okay. That's great. They need to pay for it. It changes your fees. It changes your license structure. It's not something that is, quote, included. And only by doing this can we convince the world that there's value to this. There's value to the things that were stolen in the last 5 years. So some of you will always use a no AI training clause. Some of you will never use it, which is fine too, based on your industry. And then most of you will have a default of no AI training for images that are delivered unless it's part of the license agreement, which changes the price of the license agreement. Right? I hope that makes sense. Hope that makes sense. And we're going to stop for some questions in a minute. I can see them coming in out of the corner of my eye. I don't want to pay attention to them right at this moment because then, if you ever heard me talk before, I will just talk. I'll just go off on a tangent. So we're going to stay focused for just a little bit longer, and then we'll stop for some questions. Okay. So the goal is that we don't. The goal is that you kind of have a default of no unlicensed AI training, right? And so, what does that even look like? And so, here's a clause that you're going to start seeing appear in ASMP templates and contracts and other places that are around. So, that is no unlicensed AI training. Images delivered under this agreement may not be used, either now or in the future, as source material for any generative AI model or system, either now known or that will be known in the future without a prior license from the photographer. Now, there are a couple elements here that I want to touch on. So notice that it says now known or known in the future, and it says it twice. And why does it say it twice? And this is purely a legal thing, which is there are two elements here. One is the phrase source material, and the other is talking about the models or systems themselves. So the models or systems are something that we could absolutely see changing. The use as source material is something that is time based. And so you can't use it now or in the future, and you can't use it on things that currently exist or will exist in the future. Those are two separate things. And so you want to address them both, right? You want to address them both. So this is one of the first clauses that you're going to start seeing around. Now, let's take a stop here before we start talking about output, and let's look at a few questions. And I'm looking at the Q&A. I'm also looking at questions that you all submitted prior to this town hall. And look, I will fully admit some of these town halls are going to be like information heavy. This is one of those. Okay. We're not looking at great images. We're not talking about, cool places to go. We're talking about like hardcore legal stuff. Right. And so, we'll ebb and flow on that, but we think it's important to get this information across today. Okay. And so There are a few questions, and one is, and let me make this totally clear. One is, these videos are recorded; they'll be available to the general public. You don't have to be a member to get them. Two, if you are a member, you get to visit our document library. And that's over at the ASMP Academy, powered by Sony. This document library has 23 different templates and guides that you can use, guides to your LLC, guides for architectural photography, property releases, talent releases, COVID-19 documents. Yes, some people still need them. Assignments and licensing is really what we're talking about right here. We have 6 different versions of license agreements that are located in here. And, what these are meant to do, go ahead and show you here. Here's an example of one. I think this is the short form license agreement, even though it's 5 pages. But what these are meant to do are provide templates for you that you go in and modify, and you pull out things you don't need, but we try to include a lot. Okay, we try to include a lot so that you can pull out the things you don't need. And so here, for example, is kind of an internal license agreement, a grant of rights within a larger contract, a larger assignment contract. So it starts talking about these things, and payment and confidentiality and all the term and termination and everything. This is one of these 23 documents that exists there in the document library for you to use. So if you are a member, you will be able to access the document library after you log in, and we will make a note on all these agreements when they're updated with the AI language that we're talking about today, plus a few other things. We're also going to be creating a separate AI clause document that goes into kind of this framework that we're discussing here. So that was one question that came in. Definitely want you to be aware of that. So a couple other questions before we get to the output side of things. Question here. Let's see. Okay. Can the no unlicensed AI training agreement be extended to client use? And then that also, there's a follow-up, does the agreement cover the purchase of an image, like a fine art image, to a collector? Those are great questions. Great questions. So the answer to the first one is yes, because in almost every agreement that we provide or that you should provide, there should be a line in there that talks about third-party usage, right? Which is essentially, hey, this contract's between you and me, person who's hiring me, and I'm delivering the images to you. The license that I'm granting with these images says that you can't just give them to someone else and let someone else start using them. This is a license between the two of us. There's this idea in the law called privity of contract, right? Where you can't have like third parties coming in and if they're not a signatory to the agreement. And so by definition, I would encourage you all to have a third party clause that is in your agreement. And I won't, I will switch back. I know I'm doing a lot of switching today, but I just want to show you, since I'm referencing it, right here on the page you're at, third party rights. Nothing in this agreement will be deemed to be a grant by photographer, but license, sublicense, or other granted right to client to use any third-party rights or rights under any third-party license. They can't be licensed without getting agreement by the client. We have some version of that in a number of these agreements, right? And so, yeah, you should be saying, this license is not something that you can just give to someone else or let someone else use. This is an agreement between us. Now, if your no unlicensed AI training part is part of your license agreement, then that's incorporated into it, right? That's part of it. The question actually gets a bit murkier, and it's a really good question. The question gets a bit murkier when we talk about fine art images or images that have been printed and someone buys a print. this is one of those dangerous questions. I'm going to try not to go too deep down the rabbit hole, but I do enjoy talking about this one because when you buy a print in a gallery, what you're buying is title to the physical piece. You're not buying the underlying copyright. You're not buying the intellectual property rights. You're buying title to the individual piece, which inherent in that title gives you a grant of rights to display that work in any way that you wish to display it to a point. What do I mean by that? How many of us have ever watched a television program where they blurred out art that's on the wall of a house, that they're filming inside? The reason is that the person who bought that piece of art doesn't have the display rights to use in a commercial type television program. They have the right to use it to display it in their own home for their own personal use. That's kind of part of the inherent license agreement of the title because they don't own that underlying copyright. It's the person who owns the underlying copyright that allows it to be used in different venues and media. However, if I own title to a physical object, there are a lot of things that I can do with that physical object, right? And, one of the challenges that we're going to be talking about here is the challenge in figuring out who's actually used your stuff and if anyone's breached these agreements. And it's very hard to figure out. Okay, it's very hard to figure. It's incredibly hard. If someone buys a fine art print of yours and then they take a picture of it with their phone and they use that secondary picture to put into a generative AI model, is that a breach of a tacit agreement that someone didn't really sign when they purchased title to the thing? Is it a breach of your copyright rights of display? I mean, there have not been any cases about that for sure, because we're so early in this process. I am going to, as a default, right? I'm going to say that if you have any concern about that, or if your primary part of photography is in selling fine art prints, maybe you have a clause about this. Maybe it's not a formal contract, but a clause in the agreement that the buyer, when they pick up the work or the purchase agreement, whatever it is, where you might say, hey, you're buying title to this. This doesn't include any future rights, including rights for AI training. That might be a good idea. That's something that I honestly hadn't thought about a lot, but I think is a very good question. Okay. Yeah. So the question, the next question is one that I just kind of brought up a little bit, which is how does anyone know if someone's used your work in this way? We're going to circle back around to that in a minute. I want to jump back to the output side of things because I want to get to other questions before we end today. Okay. Hopefully this is enjoyable. You all have not fallen asleep yet after 53 minutes of me talking about this, and I'm glad that you are here. So let's talk about output. And really, when we talk about output, we're talking about results and modifications. This is not the input training part. This is now the output part, right? This is the modification part of the equation. Often in our contracts, we have something like this. Images may not be altered, modified, retouched, cropped, or edited in any manner without written consent. Client can't change, remove, or alter the metadata, from the image without photographer's permission, and doing so violates the DMCA. That's a whole separate conversation. But many of us have those in our agreements. That's kind of some of the standard language. That's some of the standard language that is in the ASMP templates as well. So let's see here. Now, our clients have the same access to technologies that we have, right? And it's a trivial matter to take these images and alter them or change them with generative AI tools. We all know this. We're not like in some secretive world where we have access to something and the general public doesn't. That's kind of the biggest problem in some areas about this. But whether or not you allow those tools to be used to edit your work can be stated in your contract. And like everything else, I mentioned it differs from industry to industry. So, how do we change this? What does the new clause say? What does this new language say? Everything in yellow is new. It's the same thing we just read, but this is kind of the new part. So, images may not be altered, modified. First sentence the same. This clause includes, without limitation, using now known or will be known in the future generative AI tools and models to affect the same. That feels clunky, but again, what it's saying is that, hey, you can't alter, modify, retouch, crop, or edit without my permission. Also, you can't use any other tools that are based in generative AI technologies that are either now known or will be known in the future to do the same thing. Okay. This is just a few lines, a sentence that you can put in that will actually cover quite a bit of things. And I titled this Post Delivery AI Manipulation, which is a very specific title, but one that I think makes sense. And, um, uh, you know, what I want to say about this is, we're just talking about, well, how do you tell? It is next to impossible to tell if your work has been used as part of a training set for an AI model, right? That's, we can talk about some of the things that we're working on that front. We're working on things like, collective licensing. We're working on things like, demanding a list of things that have gone into a training model. It's an incredibly hard task. It is far easier to say, hey, I shot for this client. That's my image, but that's not the person I photographed. That's my image, but that has been changed in significant ways. And it's clear that that was done with generative AI tools. And so by talking about what a client can do post delivery in your contract originally, right? By talking about that, you're able to get in front of this. And this isn't about like some gotcha moment, but this is about, and this is what I always tell members. So every Tuesday morning, if you're a member, you can sign up for a one-on-one legal clinic session. Most of the time it's with me. It could be with some other attorneys that we work with. And we get to talk for 15 minutes about anything that's going on in your world. And what I always tell members is, hey, look, you know, everything we do here is not about trying to like surprise the client. Everything we do here is to give you any tools if someone does something bad in the future. Why do you register your copyrights? So that if someone infringes you, you have a remedy. Why do you put these things in your contract? Not just these, but any clause in your contract. You put them in your contract so that everyone's on the same page and people don't do something bad. And if they do, you have a remedy. What I always told my clients in private practice at my law firm was, hey, look, what you should do every year is, maybe you don't have to talk to a lawyer every year, but every year you should sit down at the beginning of the year and say, what bad things happened to me in my business last year? How did I get screwed over by a client that I did not expect? You list those down and then you figure out how to put those into your contract for the next year. If you do that for 2 or 3 years in a row, you're going to have a pretty rock solid contract based on your specific situation, right? That's core, what your situation is. So going back to modification, using AI tools for modification, this is an important piece. And you get to decide how serious or not serious you want to be. You may not care. And that's okay. And that's one of the things I want to get across here is that it is not ASMP's position that generative AI is bad and you're not allowed to do X, Y, or Z and all of this. It is ASMP's position that if you are going to give up a right that you have as a creator, that you understand what you're giving up and you decide to yourself the value of that right. There are industries where it is standard and common practice that when a photographer finishes a shoot, they transfer the entire copyright to the client, period. That's what they do. The person who owns the copyright has the rights. So if you transfer your copyright to someone and they want to use it for AI training and they want to manipulate it after the fact in a library, fine. But you can't do anything about it. You gave them the copyright. The copyright's the key to everything. if you haven't gotten that from listening to me talk for probably nearly a decade. Copyright is the key to everything that we're talking about here because it's the core of all your rights. It is the reason we can write a contract because it is the only thing you have that you own that affects the whole situation. So when it comes to post-delivery manipulation, you may have a client come to you and say, hey, look, I mean, I want to use this in my library and I'm going to change it up and I'm going to do lots of different things with it. And I need to have that be part of this and you need to be cool with it. Okay, put that in the contract and it costs more. Or that's part of a negotiation or that's part of different terms, right? But it's a valuable thing. It shouldn't be something that that you just give away. It's something that has value to it. How much value it has is up to you and the industry that you're in. But we want you to be able to calibrate that value by using different clauses in your agreement. And so in the final version of this, which you'll see online in the document library, there'll be kind of different versions of these that I'm showing you here that are like, for different situations. And you get to pick and choose. You get to pick and choose which ones you want and which ones make sense for the type of work that you do. And so, those are the two pieces we often think of with generative AI, the input and the output. And so we have two new clauses, the no AI training and the no AI manipulation and post-delivery, changing. But let me stop on that for a second. The clause that we use, which says you can't edit and you can't crop and you can't everything else, literally 8 times out of 10, you will modify that in some way. If I'm delivering something to an editorial client and it's a horizontal image and they want to use it on the cover, they have to crop it. That's fine. You can say, hey, client, you can't edit and alter and change and modify, but you can crop. That's fine. You can do that. So you just cross that part out. You just take it out of the contract, right? It depends on the situation that you're in. Contracts are living, breathing documents. And the one thing that I would encourage all of you to take to heart about contracts is that a contract is not a take or leave it proposition in either direction. You get to make changes. They get to decide if they want to accept your changes or not. A lot of times they'll say, no, I don't want to accept that change. And then you're in a negotiation. But if you give them a contract and they make changes, then you get to decide if you want to accept those changes. So they may get your contract, which says no cropping. And they may say, look, we can't use this if we can't crop it because we're a print magazine and this is what we need to do. So to say, fine, they cross it up. That's kind of the process of contracts, right? Little aside there, but as we're talking about contract clauses, I want to make that clear. Okay, but there's one last piece I mentioned, and this one's important, and I want to talk about. So remember that the last session, we talked about possible exposure of liability that photographers may expose themselves to based on their use of generative AI technology, not your clients, your use. In a nutshell, generative works that are entirely created and using generative AI tools, from text prompts and other things, or parts of those images are not protected by U.S. copyright law. They're not eligible for copyright protection. So if you're utilizing your tools, generative AI tools in your images for parts of your image or the image as a whole or whatever the case is, you need to disclose that to your client. You need to tell your client that you are using either large portions of AI or some images maybe have generative AI work in them, whatever the case is, you need to say that. Now, we're not talking about minimal stuff, right? We're not talking about, using a minimal brush or tool to remove a twig that's in the background of an architecture image. We are talking about things like replacing an entire sky, though. Let's say I was shooting an architectural job and I decided to replace the sky, which, again, is something that every architectural photographer has done. They normally have a library of skies. They're ones that they've shot. But instead, this time they do it using generative AI tools. That part of the image is not covered by US copyright law. It is not protected. Okay. It is not protected. And the reason I say not doing so is the dangerous game is because if you are working with a client and you deliver them images and you have not mentioned this part of it, and then something happens in the future where they're involved in a lawsuit and they find out for the first time then that the images you gave them aren't protectable and their competitors can use it and all these other things, you're going to get sued. 100%. It's just going to happen. So it's also important as we're talking about these clauses that we put into contracts that protect you from what your clients might do. You have to have things in your workflow, whether it's in your contract or elsewhere, where you are informing your clients of the way that you're using generative AI technologies in your workflow because and what that means for them and for their intellectual property rights. Now, for some of you who are photographing the general public, you're photographing, portraiture or seniors or those type of things. This may not be as important, but if you are photographing for a Fortune 100 company on a new ad campaign, you damn well better make sure that they understand what they own and what they don't own. And again, I am not saying this is right or this is wrong. I'm saying to protect yourself, you need to disclose these types of issues. And if you think you're close to that line where they might not own what they think they own, you need to tell them, right? As hard as that conversation might be. Now, there are photographers, I know some of them who are here today, and hopefully some of them who will be on with us in the future. I want you all to hear from photographers who are utilizing generative AI technologies in their workflow in a very active and forward facing way. Okay. Because it's important that you realize the spectrum of ways that these tools can be used. It's also important that you protect yourself. And this is an area of liability that concerns me as I look at the next few years in this kind of rapidly evolving AI space. Because I guarantee you there's going to be a situation where a company thinks they own something. And when they go to protect themselves and their work that they think they have the copyright to, there it's going to be determined that they don't actually. And I don't want to see any photographers caught up in the middle of that. So think about that. Think about if it applies to what you're doing. And again, I'm not giving you a hard line rule because there isn't one. So I said, hey, it's not taking out a twig that's 3 pixel large in the background of a totally different kind of frame. And it is if you replace 50% of the image with a new sky, maybe with generative AI tools. And then your natural question, and it is a correct one, is what about everything in the middle? And the answer, and this is what we ask the Copyright Office all the time, the answer is who knows? The Copyright Office doesn't have clear rules on this. They say you have to disclose and disclaim the parts of an image that were created using these type of tools. But again, where does it flip from needing to disclaim something to not? Where does it flip from ownership to not? It gets really tricky. It gets really tricky. That's the other thing we do when we go up to Washington, is we talk with the Copyright Office about some of these issues, and we say, hey, look, if you're using a tool in an editing program that you've been using for 20 years, and now that tool, it looks like it works the same, but it's utilizing generative AI underpinnings. Does that mean that now I have to disclaim the areas that I use that tool on in my image? That would be ridiculous. But we're also in a world where no one quite knows the real answer to that yet. So all we can do is talk in really extreme tones. Over here, it's not going to matter. And here it definitely does. And most things end up in this gray area. What I would recommend to you is you take a hard look at your workflow, how you operate with your clients, client information. This feels to me, if I were still, uh, you know, uh, a professional photographer, this is the type of thing that I might have in, client conversations very early on, or, maybe they initial and sign off on the fact that, hey, you've hired me to create these works for you. As part of that, I'll use all commercially available tools. These may include generative AI technologies. Please understand that the US Copyright Office says that generative AI technologies are not protectable. However, when I do use them for more than a certain part of the image, I will let you know, that kind of thing. You probably need to start having a policy about that, right? And what I just said is probably pretty close to what I would say if I were doing it right now. But I will tell you this, that piece of it is so industry specific and so you specific, meaning how you deal with your clients, right? How you negotiate your contracts or you enter your emails and your phone calls. Because it may not make sense to have something incredibly formal, or it may really make sense to have something formal. It may really make sense to have something formal. Okay, good. Let's keep going. And then we're going to get to some questions, which is right now. I'm not even going to go back to the slides. It just says that the next town hall is May 20th at 3 p.m. So definitely we want you there. Okay. All right. So now let's go through some questions, both questions that were sent before and questions that we have now that you have put in the Q&A, and feel free to put more in the Q&A if you wish. So first question from Carolyn, how soon will the increases in those copyright fees be implemented? Not immediately. So when there's a notice of proposed rulemaking, and then there's comments that come out that can be submitted, like the ones that I showed you that, the Copyright Alliance submitted, pushing back against this, right? They take all that information, they read all those things, and then they have a final rule that comes out. And that final rule is the end result. And sometimes that final rule differs a lot from the NPRM that came out. So it very well could be a final rule, says something totally different and the numbers are different. On this one, right? On this one, because of the way this information was generated, so the Copyright Office has an economist, and they really tried hard in their document to prove every one of their numbers is correct. I'd be surprised if they came off it in really big ways, but there are some alternatives that we are trying to push them towards. In fact, right before this meeting, I was in another meeting, we're talking about some different ways to change these fees. I will tell you that, and this goes into the next question. So the answer to that question is not immediately or frankly anytime soon. And when we do know that it's coming out, we will let you know. Okay, let's start there. Two, there's a question about what is VACRA? VACRA is a bill. It's called the Visual Artists Copyright Reform Act of 2025. And VACRA is something that ASMP and many other organizations have been very involved in. And it's the thing that we work most on right now on the advocacy side. And in it, it has a number of elements about copyright registration. One of those elements says, hey, that 750 number for a group is way too low. We need it to be like 3,000 or more, right? That's the type of thing that even if they decided to stay with their proposed pricing, if we got that number from 750 to 3,000, okay, we're doing better, right? Now, VACRA has like 5 different main sections to it. And we definitely encourage you to take a look at it. That's going to change over the next year, I'm positive. There's a lot of back and forth that goes into these type of advocacy efforts. But I wanted to pair those two questions together. Okay, good. Next question. All right. So we have a question here that says, I put from David. Hey, David, I put some basic limitations in the file info metadata in Photoshop. Should I add AI limitations there? And is that of any legal binding? Okay, so metadata is obviously an important piece to this mix. And I would definitely encourage you to go watch that video with Santiago Leon and the Content Authenticity Initiative and some of the things that they're doing there. I know our friend Jeff Sedlick and the Plus Coalition are working with the IPTC and trying to get some no AI training clauses put in standard metadata so that it always pops up. You absolutely can put it in metadata of images. It's you you probably should. And I say that hesitantly because of this. Every one of us probably sets our camera to put our copyright information in the metadata. Legally, you don't have to, meaning the minute you press that shutter, whether you've told anyone or not, you own that copyright. But practically, there may be some cases where it helps. Same kind of idea here. If you have it in your contracts and your agreements, then you're probably pretty safe if you don't do it because you can point to a contract or agreement. If you want to have it just be a standard part of your metadata, you absolutely could. You could modify the no AI training clause and say, this image is not eligible for any type of generative AI training. Any questions, call this number, send an email here, and then you can talk about a license for it, right? Practical use, we have not seen any court cases that have dealt with that issue. We'll be keeping an eye on that. And the reason I talk about court cases a lot when we ask questions of this type is because the courts are the ones that kind of determine if that matters or not. Do you know what I mean? If a court comes out tomorrow and they say, you know what, makes a huge difference. If you don't have that in there, then we're never going to find in your favor. The next morning, you're going to get an email from us with the big headline that says, put this in your metadata because the court has held X, Y, or Z. Alternatively, if a court says, no, it really doesn't matter, I think we're in the same place we're in right now, which is, sure, go ahead and do it. It's not something we're saying you have to or must do because I don't think it changes your standing legally. I think you will see a lot with the metadata coming along in the next year from groups like Content Authenticity Initiative and the Plus Coalition and others that might, in IPTC, that might make this easier to do naturally. So keep an eye out for that. But I wouldn't say that's a quote recommendation at the moment. It is not a bad thing to do. Let's say it that way. It is not a bad thing to do. Okay. Let's see here. Good question. Always good questions from y'all. I really appreciate that. Okay. Question here from Tiffany. Do you see copyright law changing to allow AI credited content to be copyrighted? Also, given that we see some advertising with fully created AI content, is that fair use for anyone else to use? Really good question. Interesting question. Okay. So this is so tricky of an answer, and I'm gonna answer in two different ways. Okay. I have to be a lawyer for a second. I'll answer in two different ways. First, I hope that the Copyright Office continues to determine that fully AI generated works, which, I've heard a number of people argue that there is an art and a skill to creating the text prompts. I know some of those are incredibly long and difficult. You can copyright those under a literary claim, literary registration, but the output, it is my belief that that should not be eligible for copyright protection. Some people disagree with that. That's where I fall on this particular issue. I don't think the Copyright Office is going to change on that. But where I do hope they change is on requiring individuals like photographers to have to disclose and disclaim on every single image they submit if generative AI tools were used and to what extent and what portion of the image. Because of that, needing to disclaim that, you're not allowed to use the group application anymore. So technically, what the Copyright Office wants you to do as of today, as of May 6, 2026, is if you have used a generative AI tool on your images, you have to register them one at a time at $35 a piece instead of $750 at a time for $55. It is insane to expect and ask a photographer to do that. And that is one of our biggest rallying cries at the moment, that there needs to be more clarity from the Copyright Office on when you have to disclaim parts of an image that may have used a generative AI tool. Because look, I think we're all in the same boat here. Tools that we used 5 years ago are called the same thing in our software programs, but now they're using generative AI as an underpinning technologically. And in the Copyright Office's mind, you should be disclaiming that, and you may not even know that. And that matters. This isn't just a philosophical point. It matters because if 10 years down the line, someone infringes your work and you go to you say, no, I have I did it. I registered my copyright. It's right here. And the other attorney says, well, which parts were using generative AI? And you say, well, all of them. But all the ones in this group used it a little bit. They'll say, well, we need to throw out your application because you used the wrong one. You should have used the individual application and not the group application. Everything I just said has not happened yet in real life, but it's part of our job to think about the bad things that could happen and to go and make sure they don't. And so we are very much on the Copyright Office about this issue because it is a concern. Now, the second part of your question, given that we see some advertising with fully created AI content, is that fair use for anyone else to use? So yes, but it's fair use in the copyright context, but it's not fair use on the trademark context, right? And so, you can't like take, the recent AI created Coca-Cola ads and, start putting your own products in there because there's Coca-Cola trademarks and other things that are involved. There's other intellectual property issues at play. But as a functional answer, images that are created or videos that are created with entirely generative AI text to image technology do not have a copyright with the US Copyright Office. So it's not even fair use, it's just public domain almost. Because fair use says, hey, I know that I'm using a copyrighted work, but it's okay because of A, B, or C. Public domain means you can just use it. I don't want you all to go out and just start using things that you think are created with generative AI. We generally want to shy away from that, but I think the idea remains the same. Until the Copyright Office clarifies this issue more, I think you're correct, absent any trademark issues or other intellectual property issues that might be involved in that. That's a really good question. Okay. Question here. What if I composite my own sky images versus AI sky replacement? Yeah, here's the thing. That's fine. Meaning, if you're using images from your library, if you have 1,000 layers going in Photoshop, if you're doing all these things, that's no problem. That's not any copyright issues at all. That's established law. We feel good about that. We feel good about the fact that finished work is just fine. And even if it looks exactly the same, but it was done using generative AI tools, that is a problem. Because what the Copyright Office says, and this is what I was just talking about, and something that I know I agree with, right? My mind is always open to being changed, but I know I agree with. And that is if I type in a sentence or a long prompt, and some of these are incredibly detailed and great, and I'm not discounting that at all. And then it is a computer model that assembles those pixels in a way that I can view it. The human hasn't done that assembly. The human's given the instructions and the machine's done the assembly. And the question then becomes, well, even though these skies look exactly identical, this one was done with compositing of images that the human took and put together by the human, and this one was done not by the human. Should they have different protections? I think that answer is yes. I think it should be yes. Earlier I was talking about, hey, I'm not here making moral judgments about X, Y, or Z. This is all about your business and your contracts. There is a point, right, where you kind of say, okay, I understand that this should be eligible for protection and this should not. Think about the very famous Naruto monkey case, where the monkey grabbed the camera and took a picture. And there's a big thing about, does the monkey own the copyright to the picture? And that actually, surprisingly enough, underpins a lot of the recent AI decisions on this particular fact. And it's something the Copyright Office itself used by saying, hey, we've held in the past that only human authors are eligible for copyright protection. If you're not a human author, you're not eligible for copyright protection, right? and it started with the monkey. And so we're kind of still going down that route. Now, I should have said this at the beginning, but I'll say it now as we close. And that is, um, everything I tell you today could be totally upended tomorrow. We are not in a world. If you and I talk about contract law, if we talk about copyrights, we are building on hundreds of years of legal rulings. I know what's coming because 1,000 cases have shown that this is what's coming. We are in a world where every single case that's decided right now is creating new law, and it's making things different for us in real tangible ways. And so everything I said today is true as of May 6th, 2026, but it may not be next week or the week after. And that's why I definitely encourage all of you to come back on May 20th, which is 2 weeks from today at 3 p.m. Eastern for the next town hall. You'll be getting all this information and all these links. We'll try to put it all together. As well. I know that there are some questions, and I think a question just came in. Yeah. And I'll just look at I won't have time to answer, but I think it's a good place to end. It came into the chat, but do I worry that broad AI restrictions could accidentally prohibit legitimate photographic workflow tools, especially as the line between capture, processing, retouching, and generation becomes less clear? Yeah, it is incredibly important to myself, our COO, Melanie Porter, who I think many of you all have met and will be on a town hall here in the future, I'm sure, and our national board and the organization, that our role is to help support professional photographers wherever they are and whatever tools they use and how they're using them. And we want our members and we want this industry to thrive. And we want this industry to not be a put your head in the sand and, I hate all this AI stuff. We want to find ways to use it. We want to find ways to use it in your workflow that makes sense. And there's always the concern that if you're too overzealous in one direction, it could stifle creativity in another. And we really are cognizant of that. And we really think about that when we make some of these arguments. And it's part of the reason that ASMP, until this series of town halls, has not come out with the kind of concrete language that you saw today, because we wanted to wait and see how some of these things evolve. And if I did this town hall a year ago and tried to write these clauses, I'd have to rewrite them, 6 months ago, because I would not have felt the same way. Okay. I think as we as a society become more used to generative AI technologies, I think what we have to do is find that balance and find that line. And I'll be totally honest with you guys, it's a hard line to find, but that's why we're here. And that's why we're going to help protect you, and we're going to bring you the information, and we're going to make sure that you can incorporate this stuff in ways that supports you in your businesses and your careers and doesn't take away from it. That may not be the most concise answer, but it's one that we do care about a lot. I want to thank all of you for coming today and for the questions you posed. I know we didn't get to every single question. We are going to do this every 2 weeks. And as I mentioned, I will be in Washington next Tuesday for this hearing. I hope you all can watch that. Melanie Porter, our COO, and I will be up in Portland for PDX Squared next week on Friday and Saturday. We hope you can come to that if you are in the area. There are only a few tickets left to that. And definitely want to thank each and every one of you for coming today. This will be on YouTube. We'll get you links and everything else. Thank you guys so much. Really appreciate you coming.